So good morning, everyone. Thank you for joining us today. My name is Alexandra, and I'm a librarian at the Arlington Public Library. I'm joined today by my colleague, Megan, who will be monitoring your questions on the Q&A. Megan should be available for viewing.
Hi, everyone.
Before I introduce today's guest speaker, I'd like to go through a few important items. This presentation is an educational program on estate planning. It will explain and discuss individual estate planning and the important documents involved. This presentation will be delivered by a licensed attorney in the state of Virginia. This presentation will not cover personal finance or financial planning. It will not provide legal or tax advice. If you are looking for that information, we recommend that you contact a CPA, which is a certified professional accountant, and a financial planner. Arlington Public Library uses subject matter experts from a variety of sources to provide educational public programs. We do not endorse, suggest, or recommend a specific company, service, or product. Now allow me to introduce today's special guest speaker, Toula Dreifuss. Toula Dreifuss is partner and co-founder of the S&T Law Group. Ms. Dreifuss provides real estate and estate planning legal services to clients in Virginia and the District of Columbia. I'm delighted to welcome you today, Toula. Thank you so much for joining us.
Thank you. It's my pleasure. Thank you for inviting me and for the opportunity to share all this information today.
Thank you.
All right. Well, I'm going to go ahead and get started. So there was a lot of interest in this particular subject right now with everything happening in the world. It does sort of lead people to take stock of documents, plans, things that bring them peace of mind in general. And so this is a very timely presentation, I think, and I hope you'll find it really helpful. We're going to cover a lot of ground about the documents involved, the process. This first slide that you're seeing will show you sort of our roadmap for today. So we're going to start with an explanation of estate planning and why it's important. We are going to talk about the specific documents that are included in a comprehensive estate plan, the role of each of those documents, why they are important, how it is that you can update an existing plan, which is a very common occurrence as life continues and phases of life change, and then considerations as you begin preparing your own estate plan. I do feel like I need to offer apologies before we start. For those who have never begun this process or had any conversations about your own estate plan, everyone comes to this place differently. Some people feel strongly they want a plan just because. Some people have helped or watched a family member help someone else that they love go through the need for powers of attorney, loss of capacity, early onset dementia, Alzheimer's, those sorts of things, and whether documents were or were not in place, how that process went. Or maybe the administration of an estate that didn't go as smoothly as possible. And so the point of today's presentation is just to arm you with a whole lot of information about what's involved so that you can then decide what your next best steps are. I'm going to answer sort of right off the bat the question that was asked a lot in your advanced questions, which was, how do I do this on my own? Can I do this on my own? What online resources are available? The Arlington County librarians are phenomenal. They have a list of resources for you for online services. I don't endorse any specific services. I will withhold my opinion about documents that are prepared without the assistance of an attorney. I have seen documents that would be just fine and were comprehensive enough to reach the client's goals when I have reviewed them. And I have seen documents that needed extensive rewrites and edits to make sure that they were compliant and effective. And the thing about estate planning documents is you may never know if your documents are effective. You may not be here, or you may have lost capacity. So I do recommend having documents reviewed by an attorney if you feel that that is something you want to do. That service is certainly available to you as you decide is best for yourself and your family. I also feel like I should offer apologies in advance for, again, those who haven't done this process before. Estate planning is contingency planning just at the heart of it. And so you plan for bad things to happen and then maybe more bad things to happen. And so we talk about common accidents, we talk about dying and illness and death. And so I apologize for that in advance. You may all need to go out and get a nice walk in the sunshine and some fresh air after we're done. It is a little bit of a heavy topic. It takes a lot of emotional energy to talk about these things, especially when you're applying it to your own life and your own family. So just know that going in. All right, I think we can start with the first slide. So who needs an estate plan? In general, if you've got people in your life that you care about and you want to make sure are cared for, and you have stuff in your life, you will benefit from having an estate plan. That is just the core of it. We'll talk in a little while about what happens if you do not have a plan of your own, but I can tell you that there is peace of mind for you getting documents into place to make sure that you have a plan that you have created for yourself. It is important, I'll say this here and you'll probably hear me repeat it a few times. It is incredibly important to put these documents into place while you have the capacity to do so. The goal of estate planning, and actually we can go ahead and go to the next slide because I'm going to get right into what an estate plan is. The goal is to put documents and an executable plan into place so that you are making decisions for yourself for a future time, for your finances, for your family, and for your health, so that it's your voice that's heard at that future time when you cannot speak for yourself. It's going to happen to all of us. There will come a time that you cannot speak for yourself. And whether it's due to illness, some sort of an accident, whether it's temporary or permanent, whether it's, it's a sudden passing and the need for documents to wrap things up for you, there will come that time. And without your documents, you during your lifetime don't have the peace of mind of knowing that your voice is going to be heard in the future for yourself, maybe for children, for other family members that you may care for. And they don't have the peace of mind of hearing your voice and knowing that they are doing what you would want. And there's a lot of value to that for most of my clients. They talk about wanting to make things easy for their family, wanting there to be peace of mind, that they considered that this moment might come and this is how they wanted it to be handled. So that really is sort of a lot of the emotional reason and truly practical reason as well for estate planning. So my bullet points here, sorry, one more time, it reduces emotional stress for you and for your loved ones. Don't discount that having documents avoids disputes. People think that when you go through the estate planning process, sharing anything about your finances is the most intimate, personal conversation you have with your attorney or whomever it is that you're going through the process with. Conversations about family relationships, who you trust, who you don't trust, who you may or may not want to leave your assets to. Those are the real personal, emotional conversations. Most people have experienced a passing in their family, and I find it does one of two things. It either brings everyone closer together and fuses you and everyone's on the same team working together, or it can drive people apart. And it may be a combination of the two with different groups of family members, but grief and money and uncertainty are unpredictable. And so having documents can help you avoid those sorts of things for your family members. And then it can actually streamline or completely avoid court and probate action upon your passing. I hear attorneys all the time talk about how the goal of estate planning is to avoid probate. I am not one of those attorneys. I happen to know the probate clerks in Arlington County very well, Fairfax County, Loudoun. They are wonderful people who help you through a very hard time of getting documents admitted into the probate process. Probate is not the end of the world. It's probably necessary for the majority of people. We'll talk about trusts and how they do help you avoid probate if that is a goal. But Virginia does not have a death tax. The federal death tax limit right now is over $11 million. So people talk about probate being expensive. It's really not an extra, it's hundreds or low thousands of dollars, if that, fees to the courthouse at the time, depending on the value of the estate. And we'll talk about how to sort of have things transfer outside of your estate as well as we go on. But just know that probate isn't the enemy. Avoiding it is fine, but shouldn't be an end all goal that might frustrate other goals that you have for yourself and your family. So just know that I don't think avoiding probate as a goal should be a priority. You should determine what your priorities are and then see how that falls with whether it triggers probate or not. All right, so we will move on to the next slide. And I think we'll get through at least the list of documents and the first document before we break for questions. Let's see, what documents are involved? So a lot of people, when they think about estate planning, only focus on documents must be to deal with death. And I am here to tell you that there are more documents in your estate plan that help you while you're living than address things when you are gone. And so here's my list of the combination of life and death documents. A general durable power of attorney, absolutely a life document, really important tool as you go through life that you may need for convenience or for necessity. We're going to get to each of these documents in detail on slides that are coming up. Healthcare power of attorney, which is also known as an advanced medical directive, also a very important life document. A living will is really an end-of-life document. So I put life documents, sort of. If you get to an end-of-life situation, it can be an incredibly important document to help your family members speak with medical professionals to make decisions for you. Your last will and testament, absolutely an end-of-life death document. Last will and testament, we'll talk about this more in detail, but it's not looked for, looked at, made a part of public record until you are gone. And so that is definitely a death document. A revocable living trust, if you choose to create an estate plan with a trust, is both a life and death document. And again, we'll get to this in more detail, but it's a way for you to manage assets during your lifetime, have assets managed on your behalf in a streamlined way if you become incapacitated, and then distribute assets once you are gone. So it really is a combination of a life tool and then a distribution document, asset holding and distribution document once you're gone. And then additional tools. Those are the core documents you hear about in estate planning, but there are other things that can be incredibly important. Transfer on death deeds, life insurance, death beneficiary designations, and things like IRA accounts, 401ks. If you've got government benefits, you name your death beneficiaries there. Those are all very important. And those should all be checked and updated to make sure that you have a cohesive plan and that things are going to happen the way that you intend. And I'll talk more about that as we go forward as well. So I'm going to get through the first document and then we'll take a break. I think some questions are coming in. So a general durable power of attorney. Let's talk about the name of this document for a moment. Well, let me tell you what it is. A power of attorney of any kind is a document that lets you delegate the power that you have to do something to someone else. And so the words that are in that document are very important. If you have sold real estate and you couldn't be available to go to closing, you might have signed a very limited power of attorney called a specific power of attorney. Well, that document was written for one purpose and one purpose only. It let you delegate the power to sign closing documents and a deed on your behalf. So you have to look at each of these documents, and you can only do what the document says that you are empowered to do. And so a general durable power of attorney contains the delegation of the business of your life. So real estate, banking, insurance. Oh, we're sliding through a little bit. If we can go one more back, I think. There we go. Yep, there we are. Real estate, banking, insurance, investments, business things related to your life if you can't do those for yourself. So back to the title of the document. General means that it's going to delegate a number of powers. And again, you have to look to the document to see if any were accepted. It may be that I don't want you to be able to sell my real estate, but I want you to be able to go to the bank and handle my banking for me. So you can choose how specific those are. They tend to be very broad to make sure that someone that you name that you trust can do all of the things that you need them to do, but they certainly can be limited. And then durable and durability in general is an incredibly important concept in this document specifically. Durability means that it does not expire when you become incapacitated. There are powers of attorney that are written to expire when you become incapacitated, which essentially means anything that only you have the power to do now requires possible court intervention for someone else to be able to step in and do for you. So having a durable power of attorney is important if the peace of mind is that someone else can help you if you do become incapacitated. So powers of attorney are helpful for foreseeable reasons, travel, those sorts of things, scheduled surgeries, scheduled, really incapacities, sort of times that you might need to recuperate from something. You may have a power of attorney in place so your spouse or someone else you trust can sign off on paperwork or make, decisions related to banking, insurance, and those sorts of things. And they're also invaluable for unforeseeable things, accidents, injuries, sudden illness. It is important to note that a power of attorney is no longer effective when the person who created it passes away. So I have had people try to do things for someone who has passed and say, oh, it's okay, I have a power of attorney. Once someone passes, you now shift to dealing with their estate. Power of attorney is not the right tool at that point. So power of attorney is only a lifetime document. They can include things like naming a temporary guardian for minor children. So I say temporary because remember, this is due to an incapacity. So language for naming a guardian, and I always recommend with any fiduciary nomination you make in your documents, and a fiduciary is someone who has ethical obligations to act for you. So, and what we're going to talk about, it's your power, the agent that you name to act for you in your power of attorney documents, it's your personal representative or executor, those are interchangeable terms for your will. What you want is to make sure that they have temporary ability to care for minor children while you're incapacitated. Your will designate a permanent guardian. And again, we'll get to that, but know that a temporary guardianship can be included in a general durable power of attorney. I will say getting these documents into place, one of the most important reasons is because if something happens and you now need one, you may have difficulty getting one prepared or executed. So I'll give you a couple of examples. Things like the COVID-19 virus have grounded people in different places in the world where maybe they didn't anticipate being. They put them into quarantine for 14 plus days where they could not have contact with the outside world. 9/11 did the same thing. Planes were grounded. People were sort of waylaid in places that they didn't anticipate being. Having a power of attorney in place could be helpful in instances like that. If back home or wherever in the world, someone needs to do something for you because you cannot do it on your own. Under present circumstances, you certainly can get a power of attorney prepared and notarized, except that you may not want to visit a notary right now. You may have reasons and health concerns that prevent you from wanting to really make any contact and be exposed. There are e-notary services. All of that is coming up. Certainly, technology is making giant, bounds forward right now to deal with all of the present need. But just know, having these things in place when there's a calm time or certainly just an ability to get it all done becomes really important. The other important thing to know is that if you did become incapacitated and you did not have a general durable power of attorney of your own, you're now in that camp of you didn't get your voice documented on paper and signed and notarized in the form of a power of attorney. And so now your voice can't be heard. And so now the court is left to appoint a guardian for you rather than have you select someone on your own outside of the court system with your own voice and your own free will and free choice for who might be the person that you would choose to make these sorts of decisions and act on your behalf. That's a whole lot of information about that document. I see a couple questions came in. Why don't we pause for those?
Yes, we have two questions. The first one is from an attendee who made a will and estate plan about 7 years ago, and it was notarized and witnessed at the time. Their status hasn't changed, beneficiaries haven't changed, nothing like that. But they're asking, what are some common examples of things that make wills no longer legally enforceable or things that they should watch out for?
So I'll answer this now. We're going to talk more about this later, but the answer is there's nothing that I can think of. So if it's executed properly at the time that it was executed, if it had the right number of witnesses and the right notary, and it still represents everything that you want, I don't see any reason why you would need to touch that document. There's nothing that expires by passage of time with these documents as long as they're executed properly. All of your provisions are preserved, and there are not generally large statutory changes that would ever impact your will. The idea of your will is to clearly express your intentions, and if it got put in front of a judge for any reason and the judge could determine that your intentions were expressed and it was executed properly, then you're going to have a valid will. It's going to stand the test of time.
Okay, the second question is, how long does the probate process take in general until heirs can take control over the inherited assets or bank accounts?
So this is a really, really great question and timely. So let's take the COVID-19 virus out of play and say that someone passed and you need to administer their estate. If you called the Arlington probate clerk's office on a normal day, they would tell you that you could get an appointment in anywhere from 2 to 4 weeks from now to open probate. They only schedule a certain number of appointments per day because it's a lot of hand holding. They don't want to rush the people that come in for these appointments. They have you bring everything in. I tell people you don't really need an attorney to navigate probate in our local counties because the probate clerks they're amazing and super helpful. And they understand they're dealing with people who are at this weird intersection of having to grieve and deal with almost business transactions for the person that they're grieving. And so the probate process in Virginia takes a year. It may not take the full year for you to distribute that. You may get everything distributed, real estate sold, all of that in the first couple of months, but then you do have to do the final accounting, the final tax return, and all of those sorts of things. Also, Virginia estates are open to creditors for 1 year from the date of death. So if I passed away today, technically creditors can, come out of the woodwork for up to a year to make claims against my assets for anything that I may or may not owe. So that 1 year time frame is really what you need to keep in mind for really being able to finalize probate for that reason.
Okay, that's it for the questions for now.
Okay, great. Well, we will move on to, and please keep the questions coming. If they're too specific, I will say this, all of this is personal. You can see how personal all of this is, and I'm sure everyone that's attending is sort of processing this and applying it to details in their own lives. If the questions are too specific or too sort of far afield, you will have my email address at the end. And so if there are any questions that I sort of punt and need to kick down the road a little bit, please do reach out to me individually and I'd be happy to help you. Again, none of this today is intended to be legal advice. This is really practical advice for you. So legal advice requires a retainer and all of those other the legal mumbo jumbo disclaimer things. But for additional follow-up questions on today's materials, I'm perfectly happy to field those by email. So look for my email address at the end. So let's see, that was general durable healthcare power of attorney. So a healthcare power of attorney is similar to a general durable power of attorney in that it has you take powers you have for yourself and delegate them to someone else to speak for you. Remember that when someone is acting for you under the power of attorney, they are standing in your shoes, making decisions for you. And so there's language in these documents that shields them from liability to themselves. They're governed by statute. There's lots of legislation that talks about their responsibilities, their ethical responsibilities to act in your best interest. But a healthcare power of attorney, different than a general durable power of attorney, specifically delegates the ability to make medical decisions on your behalf in the event you either cannot make them. So again, if there's a capacity issue and you just don't understand what you're being asked, you're being asked, is it okay to give you this medication? Is it okay to perform this procedure? But you have a concussion or you have some other condition where you can't process to give a good answer, or if you can't communicate. No matter how rudimentary, we actually address in healthcare powers of attorney, if I cannot communicate even by blinking my eyes. So healthcare professionals that are helping you will try to see if you can understand what you're being asked, see if you can communicate and answer and consent. If you cannot, that is where the healthcare power of attorney becomes incredibly important so that those decisions can be made on your behalf. So the broad powers of the healthcare power of attorney are to allow, I've given a few examples, allow medication to be administered for you, allow procedures to be performed, allow you to be moved to different facilities if you are better served by being in a different medical facility than where you happen to be at that time. So transport is something that can be consented on your behalf. It includes your preferences for whether you'd like to be maintained in your residence or if you with in-home healthcare versus being put into a facility outside of your home, if that is something, whether it's a rehab center or a retirement home or whatever the case may be, in-home hospice versus hospice outside of your home. All of those preferences can be stated in the power of attorney document. It's consent for pain relief. It really importantly addresses psychiatric treatment. If you consent in advance that if medical professionals determine that you need psychiatric or substance abuse treatment, you can actually consent in advance for that to be a voluntary admission. And that becomes important because if you have ever brushed up against this in your life, if someone that you love has needed psychiatric treatment or has needed substance abuse treatment, in the moment that they need it, they either don't know that they need it, are in denial that they need it. There are barriers to getting them the help that you as an outside person know that they need. And so if you pre-consent in your healthcare power of attorney to voluntary admission rather than a hostile admission, it makes that process easier for those that you love and that you've named because you trust them to care for you in times that you may not be able to care for yourself in a logical way. So that's important, and that does belong in these documents. It can address an end-of-life decision for anatomical gifts. So you can say that you don't want it to give any anatomical gifts. This is organ donation, tissue donation. You can limit donation to transplantation. You can say transplantation or medical research. Again, this is a very personal decision. I've had people specify certain organs that they did not want to donate for personal reasons, but anything else was fine. So again, very personal. These documents can be tailored to fit your needs. And then the ability of your healthcare power of attorney to authorize an autopsy if it's required or needed for some reason is in that document as well. Really important is this last bullet point, nomination of healthcare agent as conservator. So if for some reason you do become fully incapacitated and any court order is required, your healthcare power of attorney should make it so that that is never required. But if it's ever required, I include in my forms to make sure that they're really comprehensive, that if court action is ever required for any reason, that you nominate your healthcare agent as your conservator, so as your legally nominated guardian of your person. And that becomes important because, again, you've named people in these documents. When you go through this process, and I'm going to give you some tips at the end on how to bring yourself to some of these decisions, you've named people very deliberately and not named others, possibly for specific reasons. And so if your very helpful cousin steps forward and says, I should be her conservator, but she is the last person you would have chosen, you don't want to be in that boat. So having the healthcare power of attorney where your voice is heard and the judge nominates the person that you've named becomes really important. It looks like some questions have come in, so why don't we take a break for those?
Yes, we have one that's about the probate process again.
Okay.
The probate process based on where the person who died lives. So if you're handling an estate for someone who lived far away, do you need to go to that county for the probate process?
So the answer is an attorney's favorite answer, which is it depends. So in Virginia, a Virginia resident has to be the proponent of the will, which means a Virginia resident has to sit at the desk with the probate clerk and present the documents. And so if it's a family member that's qualifying, normally they will go and they will bring a friend if they're not a Virginia resident. They will, attorneys can certainly be hired for the limited purpose of attending those appointments. So it depends on the requirements of that jurisdiction specifically. So I will tell you that probate is required both where you are domiciled, so wherever your place of primary residence is in that state, and specifically in the county courthouse, and wherever real estate is owned. So we're not going to get too far into that, but just know that those are the requirements. But if you live out of state and that jurisdiction will allow you to send an attorney in your place or someone else in your place. Now, if you have to qualify as the executor, you generally do have to show up in person, raise your hand. There's an oath involved in being qualified as the executor. So there is a chance that you may have to travel for that reason. I do have to tell you what might spring from all of the technology that is being advanced very quickly under present circumstances with all the stay-at-home orders is that being qualified by video may become a more common occurrence. Who knows? Some courthouses are very technologically advanced already. Some have resisted even doing e-reportings of deeds to this point. All of them are very quickly coming up to speed now. So that question may actually not be as important of a question if courthouses start to adopt technology to allow for sort of a video option in the future. Great question. Was there another one?
Yes. This attendee does not have children and has no family in the area, but plans to live in Arlington for the rest of their life.
Yep.
Do they need a fiduciary to act on their behalf if they cannot take care of themselves?
I think the general answer is yes, unless you name someone. So by state law, your spouse can make medical decisions for you, but your spouse cannot go to the bank and sign something on an account that just has your name. So I know in this instance it's unmarried. without having that legal relationship, you don't have anyone that is automatically delegated any rights to act for you. You are now firmly in court action to have a guardian appointed if anything happens. So again, forgive my terrible examples, but if you're in a horrible car accident and you are in the hospital for an extended period of time, you may need people to take care of calling your mortgage company to talk to them about making your payments, speaking with your insurance company, taking care of pets and other, having conversations with people on your behalf. They will only speak to you if there's proper authority, and these documents are what delegate that authority. So it's incredibly important.
The next question is, should a healthcare power of attorney be submitted to your local hospital?
So that's a great question. So I don't think that, and I don't know about the local Inova system or Arlington Hospital Center. I was going to address this later. Virginia at large has a database. And so you're welcome to jot this down now. I'm going to give it to you again. But there's a nonprofit called Connect Virginia, and the website is just connectvirginia.org. And it is in cooperation with the Virginia Department of Health, and they actually will let you upload your medical power of attorney and your living will, which is that directive for end of life. And it goes into the statewide database. And so if anyone is looking for it, they will be able to find it in that database, because having access to these documents certainly can be a problem. Knowing that they exist is an important thing. So that is the best way that I can suggest to make sure that they're in a place where they can be searched and retrieved when they're needed.
The last question talks to the same topic. Do any of these documents have to be filed with county or state before use?
None of them, with the exception. So when you pass, your will is admitted to probate. It's not admitted before that. The courthouses will hold your originals. If you don't want to keep control of them yourself, if you don't have a fireproof box or a safety deposit box, there is apparently a shortage of safety deposit boxes, I will tell you. Bank branches are not being built the way that they used to be. So if you have one, keep it. If you think that you're going to make use of it. If you don't have one, maybe start calling around if it's something you think is important. But no, so these documents do not become public record unless, again, you put the healthcare power of attorney into that database yourself, or if a power of attorney is used to do something else that triggers public record. So the best example I have is my real estate settlement example. So I'm unavailable to go to settlement to sign for the sale of my house. So I sign a power of attorney to my husband. He now goes to settlement and signs on my behalf. The deed cannot be recorded in the public land records without that power of attorney also being recorded in the public land records to show the power that was there for that deed to be signed by someone other than me. So the general answer is no, unless there's a triggering event. So something like needing to sign a deed with a power of attorney, or of course opening probate and needing to record the will at that point. But your will is never seen by anyone that you don't share it with. So we'll talk about this in a little bit in a few slides, but it's fully revocable, fully amendable. You don't need to share its terms. People do change their wills, change the way they want to distribute their assets. So recording it too early doesn't make a lot of sense, knowing that you can make those kinds of changes.
Okay, that's the final question for now.
Okay, great. All right, so on to a living will. So living wills are probably the hardest documents for people to talk about, to conceptualize for themselves. But if you've had someone that you love or a family member get to the end of their life and not have documents in place, you probably appreciate more than most what an important tool this is and what an important document it is to have for yourself. So the living will is a let me go peacefully document. Essentially, if it's the end, and however the document defines it, but if the way that I write them, if two board certified licensed physicians with no ethical complaints, no criminal complaints, I sort of do the, two squeaky clean, know what they're doing doctors say, this is the end. There is no life remaining. There is no hope of recovery. This is permission to remove what are defined as life prolonging measures. And so it's a tough document to think about, but again, it can become very important. Without this and without a specific direction separately in your healthcare power of attorney, your healthcare agent can make this decision for you depending on the language of that healthcare power of attorney. But again, without your voice saying exactly what you want. It's subject to dispute, I guess is probably the best word. For those who might remember the Terry Schiavo case, it is the case that defines why a lot of people feel very strongly about having this document. In the Terry Schiavo case, high level details, she was injured, and there were some other details. I believe she was expecting a child at the time, and they got the baby delivered, and she remained in a coma. No hope of recovery was her prognosis. And her husband, after an extended period of time, said, it's time to let her go. And her parents stepped in and raised a court dispute over that. And I think it took 13 years where she languished because she did not have this document executed on her behalf. So just know that if this is something you feel strongly about, if you want to make sure that your family has your voice, if you want to make sure there can't be a dispute, again, it's very personal. A lot of people have seen a loved one go through the end. There are different ways for this document. If you're looking for documents to try to draft documents on your own, you will see living wills sometimes drafted as a questionnaire. If this, then that. So, if I can't breathe on my own, but I can wiggle my right toe, then this, I want you to do this. And I think that that's sort of a painful way to go through this, because you have to sit where you are right now as a reasonably healthy person and say, I'm going to check these boxes based on my best information and knowledge. And then down the road, someone that you love is going to be trying to interpret what you wrote versus what's happening in that moment. And I think that's tough. So the way that I personally write these documents is more of a love letter to your family that says, if these things happen, let me go, keep me comfortable. I'd like to have dignity. And what that does is it lets the person that you've named that you trust as your healthcare agent have a really meaningful conversation with your healthcare provider about where things are for you, what's likely to happen, and really have conversations about it rather than trying to figure out checkboxes. So just know that if you go looking for information to do these documents on your own, you are likely to find that checkbox scenario. So just be prepared for that. It's a really tough mental exercise to go through that for yourself and your loved ones. Again, the document though states your preferences for when you would like life-prolonging measures preserved and when you're okay with having them removed. There usually is included for women of childbearing age what is called a pregnancy override clause, which means that if you are expecting at the time something terrible happens, that all of this is suspended until the baby is born or until something else, again, I apologize, until something else bad happens and it seems the baby will not be born. So just know that those provisions are written in, again, contingency planning on top of contingency planning when it comes to these documents. It is a clear statement of wishes. I want to be really clear. A living will is not a do not resuscitate order. If you are brought into the emergency room, nobody goes looking for a document before they restart your heart or do other things to keep you breathing and to put you back together if there has been some sort of an accident. It is truly when you get to this end of the road and there's a lingering is really what this document is intended for. By the same token, it is not a speed things up document. It is not an assisted suicide document or anything like that. I have had clients at both ends of the spectrum. I have had clients who have said, I want you to write very clearly in this document that nothing is to be done to make things go faster, that none of this is in my hands, that, medical things can be removed, but nothing is to be added. And then I've had people say, move me to a state where I may be able to make different decisions for myself. So again, incredibly personal. I've had people who are not done growing their families decide that they do not want to execute this document. And again, that's a personal choice. When you do a full estate plan, you get to make those decisions about what language you want included. They're tailored really to your preferences and the things that are important to you. Do you have any questions before I move on? I don't see any.
No, there's no questions at this time.
Okay, so we are going to move right on to the last will and testament. So your last will and testament, we've already touched on this a couple of times, but it is the document that says, now that I am gone, this is the person or these are the people that I would like to step forward to wrap up the affairs of my estate. So in Virginia, it's most commonly referred to as a personal representative, also called an executor or an executrix for a woman. In different jurisdictions, if your documents say executor, the clerks in Virginia know exactly what that is. The phrases are really interchangeable. Virginia just uses, most of the clerks in the courthouses use personal representative in their documents, so I mirror that when I prepare them here. This is the final document for instructions on distribution of your assets, settling of your estate. It can, I don't think I included this in this list here, but it can give your instructions for whether you would like to be cremated or buried. It can be very vague and just say, I prefer to be cremated, I prefer to be buried. It can be very specific about where you would like ashes spread or where you would like your body to be interred if you would like to be buried. If you have military rights, all of that can be included to be sure that your preferences are stated for those types of ceremonies. You can put as little or as much in there as you like. If you only know that you want to be cremated, I generally write in a phrase that says, you know, and ashes spread in accordance with instructions that I leave. If no instructions are left, I defer to my personal representative to make decisions. So you can handle, again, it's all very personal, those decisions and the way you'd like to document them. Some people don't like to put all of the details in their will. A lot of the reason is practical. They just don't know yet. They're still really thinking about it and they don't want to delay signing their documents while they plan their own funeral. And so what they'll say is, we'll just put it in that I'll, you know, if I don't leave instructions, I trust my personal representative, and then they'll think on it. And they'll maybe type up a document that they leave with their will that says, this is what I would like to have happen now that I've had more time to think about it. So again, all very personal. Wills can do a lot of heavy lifting. They can create trusts in the event that they're required. So you can write in that if you have a beneficiary who is a minor at the time of your passing or is under a certain age, under 22, 24, 30, that you would like a trust created for their benefit so that someone is helping them manage money and assets, and as they grow into adult human beings, that they have someone assisting them with that process rather than being given a bag of money at a young age and having it not last because they just didn't know how to manage it, those sorts of things. In that event, those are called testamentary trusts. So you sign your will today and it has that language. That trust doesn't exist until a future time when that triggering event happens. So if you pass and you have a beneficiary that's a minor, then the trust will be created, but it doesn't exist before then. Same can be true for any beneficiaries that have any kind of a special need, and you can be very specific. The special need can be physical or mental. It can be if they have creditor issues or substance abuse or gambling issues that you want a trust created so that they are not given assets that their creditors can get to. So there's lots of ways to protect people that you love in these documents. Permanent guardians for minor children. So remember when we talked about general durable powers of attorney, that nomination is intended to be a temporary guardian, because under that document, you're hoping to recover and take custody back of your children when you're on the other side of whatever the issue is that came up. Now we're talking about your will. This is you naming permanent guardians for your minor children. With any of your fiduciaries, I recommend that you try to name a bench that is 3 deep. Try to name your primary first choice person. And I know sometimes that's hard for a guardian. It's hard to think of, again, it's a hard mental exercise to picture you being gone and your children grieving and being moved in with another person or family. Try to think about who your backups would be. Again, knowing that if your first named person also has some issue in their life and they can't take custody, if this is ever triggered, who would you name afterwards so that your voice is heard and it's your selection that is made? Let's see, names the executor that you choose to handle wrapping up your affairs and distributing your assets. We've talked about that. So again, they're handling the business, they're handling everything at the courthouse, doing the final accounting, all of those things. The will is admitted to through the probate process. So probate is the process of admitting all of your documents into that public probate record, and then also all of the court oversight that comes with probate to make sure that all the right filings are made, notices are sent to all the heirs and beneficiaries properly, accountings are done, and tax returns are filed. Wills in Virginia have to be witnessed by 2 independent witnesses. Virginia also has the ability for you to attach to your will what is called a self-proving affidavit. So let me back up. In order to sign a will and have your will be valid and enforceable, you have to have the right mindset. And so that mindset in legal terms is called testamentary intent. You have to know when you sign a will that that is exactly what you're doing. It's not some other piece of paper that you're signing. It's not something lighter than that. It is the heaviness of, I am signing a will. And so when I do will signing ceremonies, I do them the same way every time. I have a list of questions that I ask the person who is signing. You have your two witnesses in the room. You have your notary, which is normally me. And the statute in Virginia is very specific. The two witnesses and the notary have to be in the room at the same time and have to witness that the person signing the will has the proper testamentary intent and that they put pen to paper and signed it. So just know two witnesses and a notary are the standard for an enforceable will in Virginia, unless you write what's called a holographic will. This is the only exception. It's a little unusual, but I will tell you because it happens. If you are in a situation where you feel like you need to have something that's written down and put into place, but you have not gone through the process of creating a will, if you sit down and even on a sticky note, you write out, I am of sound mind, I am leaving, I leave all of my assets to, and you name someone and you sign it, and the entire writing is in your handwriting and you have signed it, that can be admitted to court as a valid will. And so handwriting, people who know your handwriting will be called in to say, yes, that's her handwriting, and those sorts of things. But as long as if there's a typed word on the page, it's no good. It has to be entirely in your handwriting. It has to look like you had control over the entire preparation of that document. So that is the only exception I will tell you. So I will skip ahead and tell you that I was going to address a little bit about present circumstances in a few minutes, but I'll address it here. We are doing will signings. There are some law firms who are not because they don't want to, they have notaries on staff and they don't want to have their notaries be exposed. I have 2 tomorrow and 3 next week that I am setting up a folding table in my law partner's front yard in Falls Church. She and her husband step out onto their front porch. Everybody's got masks. Everybody is maintaining the proper distance. The clients have reviewed all their documents in advance with phone calls and video calls, and they've reviewed the final versions before they're printed. They literally bring their own pen, walk up to the table, sign, with the witnesses there. I ask the questions properly, and then they walk away. The witnesses step in, sign. I collect everything, go back to the office to notarize, copy, and scan. And so it's the best that we can do right now, but there is a lot of, I don't want to say panic. There's not a lot of panic. There's just a lot of priority being put on getting these documents done, getting them signed off on and finalized. I do have a few clients who have said, let's wait and see. So the documents are done, but they've maintained such a nice bubble for themselves with social distancing that they don't want to do that in person. The Virginia statute right now does require in person. There are lots of attorneys and legislators working on emergency legislation to try to allow video and e-notary and all of those things for wills, but as of right now, that statute stands, and so that's going to be the requirement. I do want to address one more thing. We got a lot of questions about single parents and separation and divorce situations, and I know that doesn't apply to everyone, but I do want, it's important for you to know that whether you have a will or not, there is a Virginia statute that if you are married, your spouse has a right to a share of your estate, whether you leave something to them or not. So if I prepare a will and it says that I leave 100% of my assets to my children in equal shares, once I go, my husband can read that and say, well, I don't like that, and he can file with the court. It's not an automatic process, but he can file. And the way the statute's worded, depending on your circumstances, your spouse can take 1/3 or 1/2 of your estate, depending on whether you have children together and how long you have been married. So having a premarital agreement would trump that ability for them to take a forced share of your estate, or a postmarital agreement. So if you have a separate writing where you've already waived rights or agreed to a different share of your assets, then that will be honored. Otherwise, the statute will stand whether or not that you have a will. So just know that that is the case. And I don't know that we want to entertain any more specific questions on that. That is very specific, and it gets very quickly into legal advice, but I'm happy to share the statute. If anyone wants to shoot me an email, I'm happy to send you all of the provisions so you can see those. I think that's it for will and testament. Looks like we have a couple of questions.
Yes, the first question is, if I had a revocable trust set up today, would a court probate still be required when I passed?
That is a great question. So again, it depends. There is a way to create a trust and then make it own all of your assets to the point where probate isn't necessary. And actually, if we can go to the next slide, we're actually starting with trusts now. So this is a timely question. A trust, let me explain what a trust is so that this question and the answer makes sense to everyone if you're not familiar with trust. A trust creates essentially an entity that owns your assets, establishes a trustee to act on behalf of your assets and you. Generally, when people create a trust, they make themselves the trustee during their lifetime as long as they have capacity, and then it delegates to successor trustees that you name to step in. So it really is a way to streamline the ownership of your assets. If I have a trust and my house is owned by my trust and I pass away today, my house doesn't go through probate. Probate is not necessary before a deed can be signed. My trustee could sell my house tomorrow because powers just transfer without court oversight, without any sort of court requirement. I'm sorry, Megan, will you repeat the question? I want to make sure I hit the exact answer.
If I had a revocable trust set up today, would a court probate still be required when I passed?
Got it. So thank you. So probate is only required if you own things in your individual name when you pass, and if they are probate assets. So if all of your assets transfer through the trust or through death beneficiary designations, so if my 401k assets go through death beneficiary designations, my life insurance, but if I die with a bank account in my name, a car in my name, if the assets are significant enough to require probate or to require an executor who is qualified to act on my behalf, then probate is necessary. But the probate may be a very small estate, a very easy process. So just so that you know, when a revocable living trust is added to an estate plan. So for me and my practice, I will counsel clients that a comprehensive will-based estate plan is a general durable power of attorney, a healthcare power of attorney, a living will, and that last will and testament. And if they would like a transfer on death deed, and I didn't get into that too much, I'm going to get into that in a minute. I'm going to probably speed up a little bit because we're close to time already, and I know people have work constraints. When you add a revocable living trust, you still have a will, but what the will says is a very short will, keeps everything very private inside of the trust document, that always stays private, is never recorded. And all your will says is, anything that I own on the day of my passing in my individual name, I hereby give to my trust. So that gets recorded in the probate process. Everything gets given to your trust. It gives your executor the power to sign deeds or titles of cars or go to the bank and sign documents to make sure that your trust now owns everything. Let me go through very quickly the benefits of a trust. So the main benefits of a trust, and to be clear, a trust when you're living is a pass-through entity. A revocable trust is a pass-through entity. You still use your social security number, you still file your own tax returns, you still take all of the actions. If you've named yourself as your trustee, or yourself and your spouse, or yourself and someone else that you trust jointly, you do all of the acting until you become incapacitated, in which case you've now named your backup successor trustees. It's useful during your lifetime to help manage assets. Again, if incapacity happens, there's very streamlined, a trustee is acting as an owner, not as a power of attorney that's a third party. So sometimes a trustee has an easier time navigating managing assets than someone can with a power of attorney. It provides control, it provides privacy. Again, it's never recorded in the public record. And if you have concerns that you might bump up against the estate tax limits, it does allow for more flexible tax planning opportunities for the person who creates that trust. So you can do things in the trust like, if the tax laws in the future are going to tax my assets significantly, split this into 2 trusts and handle them this way. And so you can create tax shelters through trusts that you don't really have the opportunity to do through wills. They're just not complex enough. Trusts are a much more complex sort of creature than a will. I do see there are a couple more questions. Let's see if we can take those, and then I've got a couple more slides for that are important practical information I want to make sure we get to.
The next question is, does it matter if your will was handled by a lawyer out of state?
So the answer is, so judges want to honor your will. Probate clerks want to honor your will. So wills can be admitted if they were created in other jurisdictions. So more than half of the states have adopted what's called, it's a uniform probate, I can't remember the full name of the act, but basically that says that they'll honor, there's reciprocity and they'll honor them. And the other states have some version of that. So as long as it's been notarized, it's clear that there's a signature, the intent is clear, you shouldn't have any trouble with having a document admitted in another state.
And the next question is, are we able to designate an outside of state guardian? Does it need to be filed as part of the will?
So you can do, there can be, if it's not in your will, you can create a separate document that is a guardian nomination, and they can be out of state. They can technically be out of the country. I have someone that really wants to name someone out of the country right now, and we're having to sort of write a lot of language about if something like this happens again, you know, who the guardian would be stateside to shelter that child until the world opens back up and things can move. So really, I don't think out of state should be a reason that you don't choose someone. I think choosing a guardian is probably one of the harder choices that you make in these documents, because you have to fast forward to a time when you are gone. You're picturing your children dealing with, you know, sort of a really painful loss, and then a move. But if the move puts them with people that you feel like are the best to care for them, then that, you know, that sort of evens out some of the other considerations that you have. So those are the hardest choices, and again, they're very personal. But choosing a guardian out of state is certainly something. It happens a lot. You know, our families are spread out, so I would not let that deter you, I guess, is the bottom line.
There's a follow-up question to that,
Okay.
asking what kind of guardian you're talking about. A guardian for an incapacitated adult or a guardian for children?
I was talking about children, but your healthcare power of attorney certainly can be someone out of state. When there's a guardian for your person, unless they're planning, so when we talk about children, when you talk about a guardian, you're physically relocating the children to live with them. When you're talking about a guardian for an adult, it may be that the adult is living in a rehab facility or a retirement home or something like that. So your location out of state really doesn't affect that, as long as you can communicate effectively with the people who are doing the day-to-day care, and so that you can communicate decisions on behalf of that person and stay really connected. And with that, I think we probably, given time, I'm going to move on to what happens without a plan. So whether you know it or not, Virginia has a estate plan for you. Distribution of your assets is actually specified in the state statute if you do not have a will. So if you pass away and you have a spouse and all of your children are with that spouse, or you have no children, everything goes to your spouse. If you have children from a different relationship and you're married, your spouse gets part and your children get part. If you have no spouse and no children, but you have living parents, it will go to your parents. No parents, it goes to your siblings. No siblings, it starts looking for your other closest blood relationships. So Virginia is really good about, you know, if the worst thing happens, your assets may go to a distant relative that you never knew, but they will be related to you by blood. There are some states that stop after a few sort of generations, and then they escheat everything to the state. Virginia does not do that. If you have heirs of any kind, blood relations of any kind, Virginia will find them. So for a lot of people, their blood relationships, those distant ones, you know, sometimes they would rather have money go to a charity or to a named person or to a friend or a friend's children before going to some distant relative. So another good reason to have a will, even if you are not married, if you do not plan to have children, it's good to have your voice heard so that you know where your assets are going to go and that it's your choice. We talked about incapacity possibly resulting in court appointment or requiring court appointment. If you do become incapacitated, so again, without a general durable power of attorney or a healthcare power of attorney, somebody has to delegate the power. And so court order becomes the mechanism for that if you do not do it yourself through these voluntary documents. End of life decisions, again, may not be what you choose, and your voice isn't heard. So your loved ones do not get the reassurance that they are following your plan. And I know there's a whole lot of weight to that for your family if they know that they're following your plan. I think that's it for that. So the next slide is considerations in providing for children. And we've hit on this a bunch of places, so I'll go through this sort of quickly, but the estate plan does allow you to have as much control as possible from where you're sitting now over bad things that might happen later. So naming guardians, setting up trusts that say, I want all of their needs to be paid for until they're 22, and then at 22 they can have 25% of my assets, and at 28 they can have 25% of my assets, and at 35 let them have all of it. You get to do all of that planning if you create the documents yourself. You can do that in a will, you can do that in a trust. And then creating trust is an additional option to give you more flexibility, more options for planning. When you create a trust, the trust becomes sort of a hub to own all of your assets, and then they're distributed from there. With a will, they're distributed from sort of wherever they are. And then of course you've got death beneficiary designations, but with a trust, you can actually have 401k, federal government retirement benefits, life insurance benefits paid to the trust. And then the trust now holds all of those assets. So if you do have minor children, those funds end up in the trust and paid out the way that you have directed within that trust agreement. I will address, there were a lot of questions about single parents. So I do want to point out that if you are doing an estate plan, so first of all, if you are in the separation process, there is absolutely no reason to wait to prepare a new estate plan until after your divorce is final. I actually recommend that you go ahead and start that process for yourself. There's some empowerment to that. There's some control in that process. You can go ahead and start preparing those for yourself. Naming guardians for minor children will be subject to rights, parental rights of their other parent if they have parental rights. So know that you can name, I want my sister to have guardianship, but if your ex-spouse or the father or other parent of that child is living, does have rights, they can enforce their rights, of course, before you can name someone else. So just know you're sort of controlling as much as you can control in those scenarios. If you are going through that separation and divorce process, just know divorce does not revoke all of this. So if you did joint estate planning with your spouse while you were married, your will, anything that you will to that spouse is revoked upon the final divorce decree. So it's deemed that they predeceased you and they will not inherit assets, even if you say in your will, I leave everything to my spouse. And if my spouse predeceases to my children, it's read that they predeceased and everything will skip to your children. Only upon a final divorce decree though, not upon a separation. So just know that that's the case. Power of attorney, the general durable power of attorney is revoked upon divorce. There is no effect on a healthcare power of attorney though during the divorce process. So for a healthcare power of attorney and a trust, if you have named your spouse, those documents, there's no automatic reading them differently if there is a separation or a divorce. So you do want to take steps to make sure that you modify those documents. It looks like at least one question came in on that. So why don't I catch that while we're on this topic?
Yes, the question is, could you elaborate on people in the midst of a divorce? What do they do in terms of timing and changes to estate documents and wills?
So there's a whole lot that's happening when you're in that process, because generally you are, you're doing a division of assets in the middle of your life that you may or may not have expected to do. And so you're negotiating a property settlement agreement, you may be negotiating a custody agreement and support. It doesn't mean that you can't go ahead and create an entire set of documents for yourself, knowing they'll be subject to whatever those other documents are, but going ahead and creating general durable powers of attorney that name friends and family members that you love and trust. Same for your healthcare power of attorney. Going ahead and creating a will that says that all of your assets will go to your children or will go to your parents or your siblings or to friends or charities. You can go ahead and do all of that. And then whatever your assets are at the time of your passing, whatever came to you through the divorce process, and of course, whatever you accumulate after, that will address all of those. So that's the most I can probably share without getting into specifics of somebody's case. So again, you'll have my email address. So if you want to chat more about that, please reach out by email, and I'm happy to talk through that. It's definitely an important consideration. Let's see. If that was the only question, why don't we move on? What to do with an outdated plan? Plans can be updated, revoked, rewritten anytime. What I find is that there are people who are very diligent and they will have wills done when they are unmarried or when they are married with no children, just to make sure that it's very clear they have their power of attorney documents in place and they are very prepared for whatever might come. People tend to rewrite them after they have children, to add in their children, to set up that language in their will that if they have a child that is underage when they pass, who the guardians would be and what, how the assets would be distributed, held in trust, those sorts of things. And then I find a huge wave of rewriting of estate plans or significant amendments when people get into their 60s and 70s, because what they want to do is now name their adult children as their power of attorney agent, as their executor, to make sure that it's their now grown children who are stepping in to act for them. So my best recommendation is put a plan in place, even if it is basic and straightforward. If your life is not complicated, your documents don't need to be complicated, but they will be very clear. They'll have your voice in them, and you will have the peace of mind of knowing that they're there. Documents can address, future children that are born or adopted, born to you or adopted by you, who, become your legal children. And so these documents are meant to be elastic enough to handle things that are foreseeable. So I don't write documents unless I know that they are going to have legs at least for a while. I don't like to write them and know that they're going to have to be amended sometime in the foreseeable future. So I try to write in things that account for anything that's foreseeable for clients. So that's why it does become important when you work with an attorney to share everything. I got all the way to the point of finalizing documents with some clients last year, and at the very last minute, the husband goes, "Oh, by the way, can you disinherit everyone in my family, either related by blood or by marriage?" And I had to go back and rewrite a lot of their documents because I didn't realize that he had this priority that had not been accounted for in his documents. So get it all out, share your priorities, make sure that whomever you're working with knows what they are, so that they can brainstorm with you the best way to address all of those. And this, can be for any number of variables that exist in your life and your world that you want to account for. And then next is sort of how to get started. First and foremost, make a list of your main concerns to make sure that those are the things that are addressed head on in your documents, that when you're done, you get the peace of mind that all of those are accounted for, that you understand how they work and what's going to happen. That's where that peace of mind comes from. When you are thinking about who you're going to name for your fiduciaries, who you're going to give your assets to, specifically with the fiduciaries for this point though, think about who you trust the most, who can be relied upon in times of stress when decisions need to be made, and who will always have your best interest at heart. Do not make choices out of guilt or obligation. You may have a very best friend and think, oh, I need to name her as my power of attorney, but if she can't handle stress, if she can't handle pressure, if she can't make decisions when they're really important, she may not be your person. Even though you love her, you may need to choose someone else for this specific role in your life. So be really honest with yourself to make sure that you're naming people that can really step up and help you. Because remember, these documents, power of attorney documents, are generally triggered when you can't speak for yourself and help yourself. So make sure, don't discount naming friends over family. You may have friends in your world that know you better than some family members, know what you would want, understand you better. And so don't hesitate to name a friend who would jump to come in and help you if that is the best choice for you over a family member that you may have a more distant relationship with. And then really think about how you want your assets to be distributed. You can, specify individual gifts to people, to organizations, have a plan B and a plan C. Most couples with children will say, we want to give out everything to each other. If the other one is already gone, give everything to our children in equal shares. And I have the horrible job of saying, well, what if your children predeceased you? And again, this is that, what if there's a common accident? And then they go, oh, okay, well, if my kids can't have it, I don't want it to go to my distant cousins through the statute, so I would like for it to go to this friend's children or to this charity. So again, you get to name how things are going to happen. Pandemic considerations really quickly. This is not on this slide, but it is a consideration that I thought of after this was all put together. You heard me say that probate courts are closed right now. And so I have heard of real estate transactions being put on hold because someone unexpectedly passed away while they were under contract to sell, but nobody can qualify as the executor right now because the courthouses are not handling anything except emergencies related to child custody, child safety, and COVID-19 related cases. And they're doing all of those with distance by video with judges. And so probate is seized up right now. The offices are closed, and there's the Virginia Supreme Court just extended that order into June yesterday. And so a really important tool might become one of those transfer on death deeds. And if you want more information on that, again, you'll have my email address in a moment. But you may say, I want to leave my house to my children in equal shares. Well, if you go ahead and if they're over 18, I don't recommend this for minors, but you can go ahead and prepare a transfer on death deed and have it recorded. And it doesn't give them lifetime rights to your real estate, but it does make an automatic survivorship provision. So if that were the case, if that person passed away today with a will, they have to wait for probate. If they pass away today with a death beneficiary designation in a deed, that beneficiary can actually, if they need to, mortgage that property, sell that property immediately without any red tape or any delay. So there are ways that you can sort of expedite things a little bit. So death beneficiary designations are one of those. I do recommend that you pull deeds for any real estate that you own. Take a look at the tenancy. If you think that you own with your spouse with survivorship, make sure that language is in your deed. If you own a property by yourself, consider a revocable transfer on death deed. Once you record that, if you change your mind, you just record another document to revoke it. So again, any of these estate planning documents can be changed by you during your lifetime. I also recommend that you pull all of your death beneficiary designations on your any investment, IRA, retirement, insurance accounts. I have heard several stories, not that, within the recent past, of people who submitted their form to HR and they assumed everything was fine. And then it turns out their death beneficiary designation was never updated. And so they do not have one right now. If that is the case and you pass, a check is issued to the estate of. And where that otherwise would have been a significant asset that passes outside of your estate and directly to the beneficiary, it now is firmly in your estate and part of the probate process. So just a good sort of checkup if you're thinking about all of these things, to sort of take stock of where all of your accounts are, check your death beneficiaries, check your life insurance policies, check those death beneficiaries, and pull your real estate deeds just to make sure that everything that is supposed to be automatic in the future is set up exactly the way that you would like for it to be. And I think that's all that I have. It looks like we have another question. And I apologize, we're right at 12:15.
Yes, we have one question right now. If you later make changes to your will, do the changes need to be witnessed and notarized?
They do. So that's a great question. So wills require all of those formalities. So the same mindset that you had to create it, you have to demonstrate to amend it. So just know that that is the case. So you can't just strike things in your will and initial them. You may have actually created an invalidity in that document by doing it that way. So it's best to do an amendment to your will. The legal term is a codicil. Have that witnessed and notarized, and then it gets attached to your will so that it's all found and read together. I think we're to the Q&A. If there's any lingering questions, I know people may need to jump off. You've got work and family and other considerations. My email address is here. My phone number, that is my office line. My law partner and I were very lucky to be set up remotely before all of this started, and so we have not missed a beat. So we are open for business. So if you have questions to follow up on these materials, please don't hesitate to reach out. Email is great, phone is great, and this was my pleasure to present all the information today.
Well, thank you, Toula, for an excellent and accessible presentation. You really have demystified these documents for many. Before we go, we want to just highlight some resources that you may not know are available. The Arlington Public Library subscribes to a product called Legal Forms, and these are Virginia legal forms. With your Arlington Public Library card and PIN, you can access them remotely. Again, these slides will be sent to you. In addition, the Virginia Bar has a lawyer referral service that can refer you to an attorney. I believe the fee is $35 to speak with an attorney for half an hour. And then for those of you who do not know, the Arlington County has a public law library located at a courthouse. It's at 1425 North Courthouse Road. And due to the coronavirus, the law library is currently closed to the public, but you can email the law librarian, and the email address is below. But thank you again for joining us today. Thank you, Toula, for your presentation. On behalf of myself, Megan, and all my Arlington Public Library colleagues, we hope you stay well and safe. Thank you.